Hi, everyone. Welcome to the YIVO Institute for Jewish Research. If you're not yet familiar, YIVO is headquartered in New York City with an incredible collection of archival materials on Jewish history. I'd like to thank you for joining us for today's virtual event titled Embodying Liberty, American Jewish Attorneys, and the Case for Humanizing Public Charge. This Max Weinreich Fellowship Lecture is funded by the Rose and Isadora Drench Memorial Fellowship and the Dora and Meyer Tendler Endowed Fellowship in Jewish Studies. So today's lecturer, Hannah Zaves-Greene, is a doctoral candidate in American Jewish Studies at New York University's Department of Hebrew and Judaic Studies. She is currently the fellow in American Jewish Studies here at the YIVO Institute for Jewish Research and a recipient of the Hadassah Brandeis Institute Research Award. Her dissertation, Able to be American, American Jews and the Public Charge Provision in United States Immigration Policy, 1891 to 1934, explores how American Jewish women and men engaged with discrimination on the basis of health, disability, and gender in federal immigration law and its administration. She has taught at both the New School for Social Research and Cooper Union, and has published articles in both AJS Review and American Jewish History. If you would like to ask our speaker a question today, you're welcome to type it in the Q&A function here on Zoom or add a comment on YouTube, and we'll try and answer it at the end of the program. And for those curious, today's lecture will be recorded and posted to YIVO's YouTube channel, so you're welcome to rewatch it or share it with friends. And with that, I'll turn it over.
Thank you so much, Jane, and thank you all of you for coming. I really very much appreciate it, and I hope you enjoy. All right, here we go. When the Eastern Council of Reform Rabbis convened in October 1913, esteemed immigration attorney Max Kohler delivered an impassioned, if somewhat ambivalent, address highlighting the impact of the public charge provision on Jewish immigrants. The framing of his speech hardly came as a surprise, given the United States' tendency towards immigration restriction, amplified in the midst of the growing American fascination with eugenics. May our country not depart from these hallowed traditions, he proclaimed, so as to exclude any religious refugee who is physically, mentally, and morally healthy, not a contract laborer, and not likely to become a public charge seeking asylum on our beloved soil. From his years as assistant and special assistant district attorney of New York and his multifaceted legal and historical scholarship, Kohler possessed intimate familiarity with the tension intrinsic to challenging federal immigration law, all the more so given his vantage point as an American Jew and child of immigrants. While he argued that immigrants had the right to enter the United States, he simultaneously maintained that the United States had the right to control its borders through legislative means as it saw fit. He did not seek to overturn or even materially amend public charge, nor did he contest its premise that admitting physically, mentally, or morally defective immigrants threatened the welfare of the country. Rather, he posited his own analysis of the statute, endeavoring to mitigate the effect of this exclusionary law on Jewish and non-Jewish immigrants alike. The imprecision of the law that permitted officials to abuse it, not its fundamental existence, represented the primary problem requiring resolution. Kohler asked an interpretive question: what constituted a defective immigrant and who got to define it? The son of Kaufman Kohler and grandson of David Einhorn, Central European immigrants who followed American Reform Judaism, Kohler spent his formative years immersed in an illustrious community of American Jewish religious, cultural, and political leaders. His daily interactions with these rabbis, scholars, lawyers, and reformers, women and men who powerfully impacted American and American Jewish life, inspired Kohler's personal and professional pursuit of justice for immigrants. In his view, dedicating himself to the numerous battles against the immigrant baiters and against bigots of every description best expressed his Americanness and his Jewishness, and earned him the reputation of the champion of the immigrant par excellence. On the one hand, his legal advocacy meant protecting immigrants' rights and affording the United States the chance of benefiting from the skills they brought with them. On the other, It entailed defending and sustaining what Kohler understood as the founding democratic vision of the United States. This vision consistently animated Kohler's legal career. Far from endangering the health or stability of American life, as restrictionists argued, Kohler held that immigrants represented prospective citizens who would strengthen the United States. A year after he graduated from Columbia Law School, he became assistant district attorney in New York at the age of 23. His 5 years there, Kohler later remarked, formed the period that sparked his lifelong passion for promoting fair immigration law and advocating for immigrants. Via representing alleged aliens in multiple states and across all levels of the federal court in public charge, Chinese exclusion, and Japanese naturalization cases, Kohler personally witnessed the hazards that immigration policy posed to individuals and families seeking admission to the country. Striving to balance the cause of the immigrants and his original recognition of the rights of the government and the government's points of view, his casework emphasized the twin problems of what he considered to be unjustly discriminatory legislation and unethical administration of the laws by bigoted or power-hungry officials. By the time Kohler entered the legal profession, public charge had already existed as federal law for over a decade. His admission to the bar, however, closely coincided with Congress's tightening of the statute to forbid all idiots, insane persons, paupers, or persons likely to become a public charge, and persons suffering from a loathsome or a dangerous contagious disease from entering the United States. Pathologizing poverty and commodifying health, public charge codified and conflated actual or alleged mental and physical illness, disability, and poverty as legal justifications to debar and deport undesirable immigrants. More concerningly, in omitting any kind of standardized procedures or oversight, it granted tremendous discretion to individual immigration officials, laying the groundwork for them to twist the law as they chose. Public charge restrictions had long captivated the American Jewish press, organizational leadership, and legal establishment. Asserting that Jewish immigrants were overwhelmingly able-bodied, and in the rare instance that these immigrants needed temporary support, American Jews would take care of their own, they claimed that the law did not apply to them. The beginning of Ellis Island Commissioner William Williams' second term in 1909, however, ushered in a newfound urgency among these immigrants. Ellis Island already functioned as a perilous morass for immigrants hoping to obtain entry into the country, but Williams took advantage of what Kohler called Congress's recklessly ill-considered change in the statutory language to wield public charge as a cudgel against them. Making exclusion far more likely, the 1907 version of the law all but barred immigrants who may become a public charge, as opposed to immigrants likely to become a public charge, a shift that granted considerable leeway to individual officials to administer the law based on their own judgment. Williams instituted a harsher regime of immigration control, rooted in his belief that the law requires the authorities to detain for special inquiry all immigrants not clearly and beyond a doubt entitled to land, real or perceived illness or disability, ostensibly a means of predicting earning potential and economic solvency, served as a litmus test for immigrants' eligibility for admission. Complaining that overseas officials paid wholly inadequate attention to public charge prohibition of immigrants verified by our surgeons as being mentally or physically defective, and the insane and persons with loathsome or dangerous contagious diseases, Williams issued a circular ordering immigration inspectors to adhere to his stringent interpretation. Public charge became a general tool to exclude immigrants, even if the facts of the case were murky at best. The principal classes excluded from admission to the United States, the opening of a circular declared, are the following: idiots, imbeciles, feeble-minded persons, and epileptics, insane persons, and those who have been insane within 5 years, persons who at any time have had 2 or more attacks of insanity, paupers and persons likely to become a public charge, persons afflicted with tuberculosis or with a loathsome or dangerous contagious disease, including trachoma, persons suffering from any mental or physical defect which may affect their ability to earn a living. any non-citizen, regardless of length of residence in the United States, could fall victim to these new rules. If they departed from the country and returned, inspectors must rigorously re-examine them as newcomers. If they gained admission and remained within American national borders continuously, the specter of deportation hovered over them until 3 years had elapsed. If, during that time, they became public charges because of hospital admission, institutionalization, or incarceration, they must definitively prove that the cause of their injury, sickness, or mental health crisis arose after landing, or they would be subject to deportation. Illness, disability, and poverty, practically impossible to disentangle as the law defined them, effectively criminalized immigrants who did not fit a narrow set of constraints deemed desirable. Outraged by the needless hardship and injustice that Williams' actions perpetuated, Kohler joined forces with attorney Abram Elkus to defend immigrants who faced deportation because of insufficient funds or alleged mental or physical defect. Over the next 25 years, Kohler and Elkus brought a series of cases solely as a labor of love on behalf of detained immigrants. Certainly, they acknowledged, the United States acted sensibly in codifying appropriate general laws to preclude the entry of immigrants who would inflict injury upon the body politic, either physically, mentally, or morally. But when officials acted on the assumption that immigrants would become public charges unless they could affirmatively prove otherwise, they committed an injustice. Even worse, in failing to protect immigrants' individual liberty, they violated the most cherished traditions and constitutional principles of the United States. Kohler's cases targeted officials who exploited the law and the law's inexact language that fostered these breaches of legality. Health and ability, as defined by Congress and administered by immigration officials, functioned as metonyms for immigrants' value. Purported mental and physical defects, inherently indefinite and elastic terms, provoked a notable increase in exclusions, particularly of Jewish immigrants, worsened by the trend of physicians basing their medical certifications on sweeping generalizations unjustified in fact, like lack of physical development. Immigration officials stated concern that immigrants would become dependent on the largesse of taxpayers often served as a canard, since frequently these supposed defects had little real relationship to ability to earn a livelihood. Any individual, Kohler underscored, may become the victim of a blundering administration, wholly dependent on the rectitude of individual officials. As such, Kohler explained, we may accordingly find a millionaire debarred because he is lame, or an aged married woman, grandmother of an immigrant, both well-to-do, debarred because she may be slightly deaf or have a deformed finger. Precisely such a plight befell 14-year-old Bluma Shapiro, diagnosed as insane and institutionalized at the Manhattan State Hospital, whose case Sadie American of the National Council of Jewish Women brought to Kohler's attention. It began when a New York State Commission in Lunacy endeavored to enforce Bluma's deportation as a public charge. By the time that Kohler and Elkus came on board, federal authorities had already suspended the execution of her deportation warrant so her parents could pay for her care. But the state refused to accept any funds from her family. Unbeknownst to them, the Shapiros found themselves caught in a feud between the Labor Department and New York State over the administration of public charge, centered on the respective rights of immigrants and citizens to receive medical treatment in public institutions. 2 years prior, the New York State Commission in Lunacy had charged the Secretary of Labor, Oscar Strauss, with what it contended was his failure to enforce public charge. They insisted that New York's hospitals exist to serve our own insane, not as refuges for immigrants who may gain official entrance through the actions of the Department of Commerce and Labor. Citing higher costs of medical supplies and building maintenance, they demanded an increase from the previously determined upon rate. New York State's public hospitals received $3.50 a week for each patient, enough to cover room and board, but, they claimed, accounting for half the total cost of care. So they considered immigrant patients bonded by the Secretary of Labor to be public charges and refused to accept the bare cost of maintenance for them. Their assertion raised critical questions, all of which threatened immigrants like Bluma. Previously, payment of the prescribed rate had, at least in theory, prevented patients from becoming public charges. Now, it might not have the same effect, and the state hospital contested its legal obligation to accept any amount of money to maintain insane patients, even when friends and relatives offered additional funds. Thorniest of all remained the question of where the rights of the state ended and the responsibilities of the federal government began. If New York discriminated against immigrant patients who had lived in the state for under 3 years by declining to accept payments and coordinate financial arrangements, that might entail an illegal and unconstitutional violation of state and federal law and even international treaties. These disputes combined to animate Bluma's case. She had arrived in New York with her family in 1909 and allegedly suddenly became insane after residing here about 2 years. Although she had no history of physical or mental illness, she began to experience pervasive physical pain that her doctor attributed to significant life changes. She then accidentally dropped her baby sister, though whether any connection existed between this event and her somatic pain remained unfounded. Badly frightened by the circumstance, she became irrational and melancholy and acquired the belief that she had killed the infant, leading to her committal to the Manhattan State Hospital with a diagnosis of insanity. As promised, her family paid the preset sum of $3.50 a week for a state institution, which her mother had stated was the most that the family could afford when offered the choice between a private facility at $15 a week or a state facility at the lower fee. Bluma's doctors issued a positive prognosis, indicating that she progressed well and that they expected to discharge her, fully cured, from the hospital. Yet, since the hospital had deceptively recorded Bluma's family's financial status at the time of her admission, claiming that they fit into a higher socioeconomic bracket than they reported, the New York State Commission in Lunacy stated that the hospital had received insufficient compensation for Bluma's care. Her family desperately offered to pay as much as $5 per week as the crisis escalated, but the commission in Lunacy illegally and arbitrarily refused to fix any reimbursing charge to receive such compensation when tendered, and to accept a governmental bond against future accruing charges, claiming that deportation proceedings had advanced too far for them to accept a bond from the Labor Department. Making matters worse, Bluma's diagnosis itself remained questionable at best, the product of a skewed administration of the law rather than an accurate representation of her mental health. Doctors routinely issued misleading certificates, avowing that immigrant insanity originated prior to landing, which often turned out to be untrue. As Kohler and Sadie American both knew, in New York, this regularly culminated in skirmishes between the state and federal government. The facts are, Sadie American succinctly put it, that the national authorities put the blame upon the state authorities, and the state authorities say they have nothing to say, that it is the national authorities who insist upon deportation. Under Kohler's leadership, several American Jewish attorneys, including Elkus, Wolf, and Lewis Marshall, seized on Bluma's case as an opportunity to highlight New York State's exploitation of public charge to deport unwanted immigrants. Kohler situated Bluma's case in the context of the clash between New York authorities and the Department of Labor. Secretary Strauss condemned New York State's actions, while the commission in Lunacy demanded Strauss's removal from his post. Bluma, meanwhile, got caught in the crossfire. New York, Kohler asserted, overreached its authority in manipulating public charge as a rationale to deport immigrants. The commission had lied to the judge ruling on Bluma's case, asserting that she was incurably sick, an easily disprovable fact since Sadie American had a letter from Bluma's treating physician affirming precisely the reverse in her possession. Evidently, the commission was in error as a matter of law by dishonestly representing Bluma's illness and her family's financial status. Even beyond this, Kohler indignantly averred, they have gone to almost inconceivable lengths in violation of law to force this poor child to become a public charge and be deported. Bypassing the commission in Lunacy, Kohler penned a letter directly to the governor of New York, requesting that he confirm the state of public charge regulations with the attorney general. Specifically, he asked the governor to verify the directives regarding mentally ill immigrants who had lived in the state for under 3 years. As Kohler understood it, he wrote, "The law required the commission to fix standard rates for all prospective patients, irrespective of citizenship, rather than determine rates on a case-by-case basis following hospital admission." The commission, conversely, through what he diplomatically called its misconstruction of public charge, had committed and is continuing to commit grave errors affecting the rights and liberty of a number of unfortunates by preferring citizens to immigrants for care in state institutions. Pursuant to their directions, Kohler informed the governor, aliens are, on occasion, refused admission to state asylums, and establishment of rates for them is at times refused, and they are discriminated against in favor of citizens, all of which we understand to be illegal and in violation of the state and federal constitutions and subsisting treaties. Since he assumed that the commission must have misunderstood the law and acted mistakenly, he urged the governor to provide them with an authoritative exposition of their duties. Kohler had no intention of submitting charges against them, but desired to call this matter to the governor's attention so that the governor could correct the error of the commission's ways. As they had cited an obsolete and superseded legal provision to defend their behavior, it followed logically that their lapses must derive from an inaccurate conception of the law. In all likelihood, they simply did not know what made a patient a public charge, since they denied that the reimbursing rate, payment of which prevents the patient from being a public charge deportable under federal law, sufficed to do so. Kohler wished to learn whether the established rate, if paid, would in fact prevent patients committed to state institutions from becoming public charges. He hoped that the governor would corroborate that the law required the commission and state hospital to accept any sum to defray the cost of care given to an insane patient. Expressing his certitude that the commission and hospital wished to obey the law when authoritatively expounded for them, Kohler trusted that the governor would make their duties clear to them. His letter, evidently, had the desired effect. While the records remain silent as to the governor's reply, less than a month later, the acting Secretary of Labor determined that Bluma did not qualify as a public charge from prior existing causes, canceling all warrants of arrest and deportation and permitting her to remain in the United States. At least on paper, her case contributed to a new precedent regarding public charge, which Wolf shared at the next meeting of the National Jewish Immigration Council. Under the law authorizing deportation of persons who have become public charges from causes existing prior to landing, he announced, it must be shown where the alien became insane after landing, that the insanity itself existed at the time of landing, and not mere insane tendencies or incipient insanity. Yet as the public pressure for curtailing immigration grew, the harshness with which immigration officials implemented public charge, strikingly in cases of purported insanity, intensified correspondingly. Despite the precedent Bluma's case theoretically established almost a decade prior, it fell by the wayside when 13-year-old Pauline Fink landed at Ellis Island in 1920. Not only, attorney Lewis Marshall wrote to Kohler, did the Ellis Island Commissioner of Immigration demonstrate his own personal bias in his handling of Pauline's case, he acted with a level of gross impropriety that merited decisive denunciation. Once again, the issue rested on the tension between the state and federal government over the interpretation and administration of public charge, resulting in one of the strangest arrangements of the worst of the American bureaucracy that the two lawyers had ever encountered. On March 14, 1924, Kohler appealed Pauline's case before Judge Rogers of the Second Circuit Court. The district judge, he argued, had wrongly upheld her deportation order, apparent in light of the very elaborate record involved, consisting of scores of unexplained documents inserted in the return, regardless of chronological order, and the shoddiness of the proceedings. Pauline's case concerned a critical precedent as well, Kohler stated: the right of immigrants to appeal immigration boards' decisions and to receive new hearings under the law, especially vital since courts could not review immigration rulings directly. Although Kohler's writ of habeas corpus regarding Pauline's detention had sparked the unfolding legal proceedings, he disclosed that her singularly labyrinthine story originated years before any of the parties involved had set foot in the courtroom. About 4 years prior, Pauline had arrived in New York from Poland with her father and siblings. Almost immediately, she faced the threat of deportation when examining government surgeons, Dr. Wildman and Dr. Slaughter, perhaps the most ironically named men ever to have held the position, inaccurately certified her as feeble-minded, excluding her and ordering her deportation. In actuality, Pauline experienced deafness and mutism, lingering effects of the typhus she suffered at the age of 2. The Board of Special Inquiry then disregarded the proof of Pauline's deaf mutism submitted to them, as well as that she had many family members who had lived in the United States for several years, possessed plentiful savings, earned an income, and owned a lucrative business with a job waiting for her father. The facts showed that Pauline, Kohler affirmed, was neither mentally defective nor lacked financial support and in no way constituted a public charge. The government surgeons, nevertheless, insisted that their certification was correct. Both the facts and testimony, which proved that they used a demonstrably unsuitable evaluation to diagnose Pauline, however, aligned against them. Dr. Wildman and Dr. Slaughter had used the Binet-Simon test, designed to assess feeble-mindedness, although courts had affirmed that it had limited applicability as a matter of law. The test did not and could not apply to Pauline, since she neither heard what the surgeons asked nor could answer their questions. As officials classified immigrants as feeble-minded if they demonstrated the mental capacity of a child between the ages of 7 and 12, Pauline found herself trapped in an impossible situation, foisted into a scenario that could result only in a yes or a no on the question of feeble-mindedness. She quite literally had no way of explaining to the doctors that they should attribute her non-responsiveness to deaf mutism, not feeble-mindedness. Yet, even if she could hear the questions and speak her answers, the Binet test still did not apply. Problematically, as Kohler pointed out, if literally construed, the metric used to evaluate her test results would debar all non-precocious children of 12 years of age or less. This test as to age doubtless was intended to be applied to an adult, and due allowances are made for persons lower in years than adults and for deaf mutes, which Pauline did not receive. Dr. Binet himself affirmed that his test could only diagnose children under age 10 and older adults, and merely to a degree at that, and only if administered properly. Pauline, then 13, did not fall into any of the relevant age groups, and the test could provide no valuable diagnostic information. The Secretary of Labor admitted Pauline's father and siblings and bonded Pauline to reside in the United States for 6 months. Meanwhile, the Assistant Secretary ordered further review and another medical hearing. As the law permitted, the Fink family brought a medical expert possessing extensive experience with mental diseases, who affirmed that Pauline was not feeble-minded and demonstrated the inapplicability of the governmental tests for feeble-mindedness to a deaf mute. Simultaneously, he proved that she responded to tests for 12-year-old children. Although the board, again with Dr. Wildman presiding, did certify Pauline's deaf mutism, it still declined to concede their original error and eliminate the finding of feeble-mindedness. Even this obvious conflict of interest, Kohler argued, represented a fraction of the injustice that Pauline encountered, since the boards defined feeble-mindedness so as to include cases not contemplated by the statutory term, if correctly construed, and by reason of illegal age tests and other tests inapplicable to a deaf mute. Pauline's bond from the Secretary of Labor enabled her to begin studying at a public school for the deaf the following January, which she attended regularly as an earnest and attentive pupil. Her progress hastened noticeably after a successful operation in November, when a surgeon operated gratis to remove enormous tonsils and adenoids that he felt had slowed her mental development to that point, though he quickly added that she showed no signs of feeble-mindedness. Meanwhile, the acting secretary extended her bond shortly before it expired and ordered another hearing for the fall, at which time the board again confirmed the existing certifications. The secretary, however, prolonged Pauline's bond for another term. But the Ellis Island immigration authorities had still not finished with her case. Dr. Wildman continued to sit on multiple succeeding medical boards, which in turn persisted in certifying Pauline as feeble-minded. The difficulty consists, the director of the Society for the Jewish Blind testified, in that the health service authorities refuse discussion of any case. They are so callous and so cognizant of their authority that they will not admit or let anyone suggest that they can make mistakes. Neither Pauline's school file, nor promises from her teachers that they would help her find work, nor a cohort of medical specialists recognized as leaders in this department of science, nor reports from Pauline's principal detailing that she had learned to write, lip read, even begin to speak, changed the minds of the board members. One by one, Kohler informed the court, experts with intimate knowledge of Pauline's condition affirmed that she was simply deaf and mute, not feeble-minded. Naturally, they acknowledged, Pauline required specialized education, but that in no way made Dr. Wildman's initial certification of feeble-mindedness accurate. The record, Kohler emphasized, abundantly revealed the extraordinary course of the medical board, starting with its impropriety of having the biased Dr. Wildman, after he had originally certified the girl, sit on the appellate medical board each time and as chairman at that. Finally, in March of 1922, the Assistant Secretary of Labor decided to defer all proceedings in Pauline's case for a year, at the close of which still another medical examination would occur. As the law permitted, this next examination took place in DC since, as Kohler explained, public health service doctors based at Ellis Island had never been known to change their original findings. Exactly 1 year and 1 day later, the Surgeon General convened a board of medical officers to study the Labor Department's records on the case and to investigate Pauline's circumstances, both in Poland and as a student for the past 2 years in New York City. After reviewing the plethora of documentation at their disposal, this DC board vacated the initial Ellis Island certification, asserting that Pauline was not feeble-minded. Rather, they expounded she suffered from deaf mutism, a condition which may affect her ability to earn a living. The Assistant Secretary of Labor, however, took this to mean that Pauline's admission would defy the clear and specific intent of federal immigration law, intended to admit only those who are clearly fit and who are normal in every way. This last issue now remained the open question. Based on the DC board's determination, Pauline could not be deported as feeble-minded. However, she still could potentially be deported as a public charge. As such, at this juncture, by now the middle of April 1923, the Secretary of Labor ordered a new medical appellate board to determine whether her deaf mutism made her likely to become a public charge. Critically, Kohler emphasized, the Secretary eliminated the question of feeble-mindedness based upon the certification of the DC Medical Board. According to the Secretary's instructions, this new review board was to include expert medical witnesses of the Fink's choice, and its certificate should explicitly discuss both the original board's misattribution of Pauline's muteness to feeble-mindedness and the actual provenance of her mutism. Flouting the mandate from the Secretary of Labor, the Ellis Island authorities instead pursued a series of actions that, Kohler reported, almost shocked credulity. The Commissioner of Immigration personally actually requested such lawless course to be taken as withdrawing the certificate on the untenable theory that the Washington examination was illegal, and then ordered that Pauline submit to another examination of feeble-mindedness. While the Surgeon General rejected the Commissioner of Immigration's demand, that did not stop the Commissioner from personally shaping the pending board and its mission by fiat. When his office issued directions for the board, it omitted pertinent information from the Labor Department such that, as Kohler stated, knowledge was given improperly at Ellis Island of what seemed to be an order for a general medical re-examination. Still worse, the composition of this re-examining board favored Ellis Island surgeons and baselessly denied access to one of the DC physicians. To no one's surprise, Kohler informed the court, this board of 5 entirely exceeded its jurisdiction by deciding again, by a vote of 3 Ellis Island surgeons to 2 Washington surgeons, that Pauline was feeble-minded, by now a completely irrelevant question. In a further infringement of legality, The commissioner denied Pauline access to counsel, due process of law, and the opportunity to introduce withheld evidence and expert medical testimony. Ultimately, the board entirely ignored the excess of jurisdiction and irregularities of the final New York hearing, recommending deportation. The Commissioner of Immigration then took matters into his own hands, authoring what Kohler decried as one of the most extraordinary letters ever penned by a public official to the Commissioner General. Replete with absolutely unfounded statements about the case and the credibility of Pauline's witnesses and medical experts, his letter fraudulently claimed that they had accepted bribes and their statements had no merit. Dismissing the case's chronology, Pauline's successful surgery, and exemplary academic progress, the DC medical certificate vacating those from Ellis Island, and Dr. Wildman's persistence in his erroneous feeble-minded certification, the commissioner presented the story in a wholly false fashion to sway the labor secretary's final decision. Ironically, on the only point as to which this lay commissioner had any possible authority to speak, the question of likelihood to become a public charge, he stayed absolutely silent, showing that it was not even arguable. But, Kohler declaimed, most flagrant of all is the studied effort, a la the Dreyfus case, to divert the hearing as to the alleged medical condition of this unfortunate girl into one involving the honesty of the entire official medical staff at Ellis Island, and insisting that admission of the girl would be a condemnation of them. Finally, on May 28th, 1923, 2.5 years after Pauline first arrived, the second Assistant Secretary of Labor ordered her deportation to take place by June 9th. On June 21st, Pauline surrendered herself at Ellis Island, where immigration authorities held her in custody, and Kohler produced the writ of habeas corpus that set these legal proceedings in motion. The Commissioner of Immigration, Chief Medical Officer at Ellis Island, and the Assistant Secretary of Labor ranged themselves against him, insisting that final arbitration remained with the original examiners. Since Pauline was an immigrant, they maintained, and since she had not acquired the right to enter and remain in the United States, she had no rights on American soil that had been compromised. Her entire case, they proclaimed, had no standing. Kohler and the legal team he assembled, however, stridently disagreed, as he informed the court. Citing the statutory regulations of the 1917 Immigration Act, he denied the validity of the medical evidence that instigated the Secretary's deportation order, as well as the legality of the entire Ellis Island procedure. The law excluded feeble-minded people and those not comprehended within any of the foregoing excluded classes who are found to be and are certified by the examining surgeon as being mentally or physically defective, if that defect meant that the immigrant could not earn a living. Nowhere, however, did the statute allude to individuals with deaf mutism, the sum total of the question as pertained to Pauline. The ablest alienists in the country had converged independently in their opinion that Pauline was certainly not feeble-minded. As such, Kohler argued, every medical examination and certificate from Ellis Island was incorrect because they did not heed the evidence, and illegal because the certificate of the DC board statutorily supplanted them. Pauline's deportation order not only depended on erroneous information. Worse, Kohler avowed, it violated federal law. While the circuit court considered the case, Kohler wrote to Congressman Nathan Perlman, deportations could transpire only if the Secretary of Labor believed it proper, he reminded the congressman. Since the 1917 Immigration Act materially enlarged the discretion of the Secretary in staying deportations, he asked Perlman to convince the Labor Department to hold fire until the Second Circuit had handed down its decision. As Pauline's case dealt with the legality of the regulation defining feeble-mindedness, it had ramifications for future cases where medical evidence conflicted with the immigration authority's certifications beyond its impact on the Fink family themselves. Judge Rogers upheld the district court's verdict. The Ellis Island authorities, he maintained, acted within the scope of their duties to administer public charge as they saw fit. Public charge required medical examiners to certify any and all physical and mental defects of disease observed in the alien, and immigration officials to exclude immigrants certified as feeble-minded. If these officials felt an immigrant was not clearly and beyond a doubt entitled to land, the immigrant could seek redress from a board of special inquiry. But since the statute declares that the board of special inquiry shall base their decision upon the medical certificate, Rogers elaborated, we can only interpret this to mean that the medical certificate is conclusive as to the physical and mental condition of the alien examined. The Secretary of Labor could overturn decisions of boards of special inquiry upon appeal, but not those regarding immigrants with any mental or physical disability, over whom boards of special inquiry had the final word. It appears that in this case, Rogers opined, a board of special inquiry rendered a final and unappealable decision. No authority to reopen a final and unappealable decision has been granted. No power to reconvene the board that tendered it has been conferred. No right exists to create another board to consider the case further. As such, the decision to reject immigrants classified as physically or mentally defective lay exclusively with Ellis Island boards, and Pauline's attorneys could neither appeal to the Secretary of Labor nor reopen her case under the law. Immediately thereafter, Kohler petitioned for a rehearing. Contrary to Judge Rogers' verdict, the right to grant rehearings in favor of the alien prior to deportation, he reminded the court, has been continuously exercised under judicial sanction since 1886. The Second Circuit's decision disregarded material considerations of fact and of law and important authoritative decisions that each disproved key elements of its argument, including its own prior judgment that the term final had limited scope and an inconsistent tendency. When Rogers issued his decision, Kohler pointed out, he failed to cite both Supreme and Circuit Court precedent that even stronger statutory terms, to wit, final and conclusive, do not bar an administrative official from granting a rehearing for newly discovered evidence, fraud, or the like. Especially as immigrants already at a disadvantage on American soil conceitedly lacked the usual safeguards of judicial procedure, the court must protect their right to a genuine rehearing to fulfill its constitutional and judicial obligations. In light of the principle often applied to immigration laws that statutes in derogation of individual liberty should be reasonably construed in favor of the alien, Kohler declared, the right to rehearing is one to be freely exercised in the interest of justice. Dr. Wildman's inimical role in Pauline's case particularly entitled her to a rehearing. After his erroneous feeble-minded certification, Wildman repeatedly served on appellate medical boards that reviewed her case and was deeply interested to cover up his original blunder in overlooking the deaf mutism involved by reaffirming the finding of feeble-mindedness. His certification could not withstand an unbiased consideration of the facts, while his leadership of successive boards stymied any hope of an objective hearing. Oddly enough, Kohler remarked, although the court recognized the long-standing administrative practice to grant rehearings, both before boards of special inquiry and medical appellate boards, it wholly ignored this point in handing down its decision. For that matter, the 1917 Immigration Act expressly afforded immigrants the right to receive further medical hearings when new medical data came to light, and stipulated that officials must reverse their initial decision if the evidence no longer supported exclusion, simply because the examining surgeon issued the first certification that did not necessarily make it sound. Appealing to the court's humanity, Kohler stressed that if the United States deported Pauline, she would doubtless suffer grave hardship in Poland. Conversely, if permitted to remain stateside with her family, she could continue her education, enabling her to contribute to her adopted country. The chance to stay in the United States and, so to speak, transcend her disability via American public schools would transform Pauline into a useful member of society. Not once did Kohler state that Pauline should be allowed to remain in the United States in spite of her medical condition. Rather, he professedly consented to the idea of public charge, that certain illnesses and disabilities, by definition, rendered immigrants ineligible for admission. That said, he avowed, this was not relevant to Pauline. She was not feeble-minded and displayed the ability to earn her own living. If the United States deported her, they would commit a categorical wrong. To Kohler's frustration, his petition did not succeed. On a theory evolved by Judge Rogers and not suggested by the government, he exasperatedly told Marshall, the Second Circuit flatly denied the right of the Secretary of Labor and of the Surgeon General to order medical rehearings, and intimates that the same rule applies to the Secretary of Labor's right to order Board of Special Inquiry rehearings on non-medical questions, exercised daily almost. The court's hypocrisy and its awareness that Pauline's case concerned important questions particularly perturbed Kohler. Irrespective of Rogers' cognizance of prevailing practice to the contrary, and his ruling's divergence from previous circuit court decisions, he remained intractable, even nullifying a medical regulation written by the Surgeon General and approved by the Treasury Secretary, since it contradicted his opinion. Not only did Rogers gainsay accepted protocol, he accepted his authority, risking the rights of several thousand immigrants per year. At Kohler's urging, Marshall added his name to Kohler's petition for a writ of certiorari to the Supreme Court, exhorting them to review the Second Circuit's decision. In upholding the legitimacy of the Ellis Island Authority's actions, the Second Circuit upheld a corrupt process, whether considered procedurally or evidentiarily, a miscarriage of justice that the Supreme Court must rectify. Alongside the petition, Marshall might, Kohler advised, reference in a brief note to the attorney or solicitor general that President Harding was so much interested in the poor girl's condition that he not only expressed his interest, but asked to be informed of developments in the matter. Barely over a week later, the Solicitor General sent a favorable reply, all but concurring in advance with Kohler's certiorari application and promising to support it on behalf of the federal government. Marshall and Kohler once again, upon receipt of the news that the Supreme Court would hear Pauline's case in January 1925, conferred together. While feeble-mindedness, Kohler and Marshall accepted, remained a valid reason to debar and deport immigrants, this necessitated that officials exercise due diligence in issuing such certifications. As Pauline did not meet the criteria for feeble-mindedness under any reasonable interpretation of the Surgeon General's description, Kohler maintained that legal precedent existed for the court to overturn the deportation decision themselves. As Pauline's public charge status rested on the false feeble-mindedness certification alone, should the court eliminate it, they would, by extension, eliminate the public charge question as well. Only the correct certification of deaf mutism would remain, which had no bearing on the determination to deport Pauline, since the secretary had already known about it and did not cite it in his deportation decision. When Kohler appeared before the Supreme Court, he accentuated the fraught question of diagnosing feeble-mindedness. It revealed a chasm in the law and its enforcement that required the federal government's intervention. The definition of feeble-mindedness, like insanity, is a question of law for the court, Kohler avowed, unlike its diagnosis by medical and other experts, despite the circuit court's opinion to the contrary. Pauline's tortuous case eliminated the discrepancy between the Surgeon General's definition of feeble-mindedness and the nebulous and arbitrary metrics that Ellis Island officials employed. Non-teachability, a quality that did not characterize Pauline in light of her remarkable educational process, comprised an essential element in feeble-mindedness, but the Ellis Island boards continually omitted this from their deliberations. To administer public charge appropriately, law and medicine had to work hand in glove. It was the prerogative of the law to define what constituted excludable medical conditions, and it was the prerogative of medicine to certify the presence of illness and disability as determined by the law. When unscrupulous government officials cherry-picked medical evidence and declared themselves arbiters of federal law, and when the law provided insufficient guardrails to prevent them from doing so, injustice invariably occurred. Kohler's arguments against the unjust and improper conditions at Ellis Island met with remarkable success, convincing the government to take the very unusual course of confessing error. To the happiness of Pauline's family, teachers, and members of Congress invested in her case, the Supreme Court reversed the district and circuit court's decisions and allowed her to stay with her family. For some months following the Supreme Court decision, letters of appreciation for enabling the child to remain in this country and to stay with her dear ones flowed into both Kohler and Marshall. Few expressed greater joy than Pauline's school principal, who invited them to visit her school to observe how children can overcome a big handicap. Thanks to the undaunted zeal and model of completeness embodied in Kohler's advocacy and the support of Pauline's mother and teacher, her principal reported that Pauline had progressed further this term than she has at any time since she came here. She would not only be able to take care of herself, but would be economically self-sufficient. Under the terms of the law, Pauline had the ability to become and remain an American. Pauline's and Bluma's cases tell the stories of two young immigrant girls whose alleged mental and physical illnesses nearly resulted in their exclusion and deportation from the United States, but their stories do not stand alone. About a year before Kohler took on Bluma's case, he had noted the controversy over the exclusion of immigrants whom examining physicians certified as defective in a recommendation he wrote to Congress. Even under the theory of the present statute, he wrote, the question whether alleged defect is likely to affect the immigrants becoming a public charge is a quasi-judicial question and not really a medical one, and ought to be made reviewable on appeal. The then Secretary of Labor, Charles Nagel, happened to agree with him. In early January 1911, Kohler and Nagel discussed the issue before the Council of the Union of American Hebrew Congregations. After Kohler's introduction, Nagel took the floor. You may call me a lawbreaker if you want, he affirmed, but if I break the law, it is in behalf of the alien and not against him, to do what I think must have been intended to be done, treating it as an administrative law, and I do not strain it to accentuate hardship or to bring tears and sorrow. Shortly thereafter, Kohler penned another letter to Congress to share this conversation with the House Rules Committee. As an American citizen who has interested himself actively in the administration of our immigration laws ever since 1894, Kohler expressed his eagerness to assist in exposing conditions of despotism and arbitrary violations of individual rights, he told Representative William Sulzer of New York. As Kohler well knew, autocratic immigration officials had a storied past of bending public charge to their will while Congress looked the other way. Bluma and Pauline, thanks to his intervention, managed to obtain justice. Their experiences, however, represent but two among the fragments remaining in the historical record of the thousands of immigrants termed defective who lacked a Max Kohler to come to their aid. Thank you.
Wonderful. So we have time now for a few audience questions. If anyone is interested in posing a question to Hannah, you're welcome to type it in the Q&A function here on Zoom. I'll also note that I see we have Barbara Drench in the audience with us today, so thanks for joining us and thank you for your support. Our first question from one of our audience members is this. It would help to know how many persons were seeking to come to the US during certain years, how many were denied because of public charge rules, and how many were deported. Could you put, I'm going to say estimate numbers with various categories and various years? Many thanks.
Yes, absolutely. So I don't have the statistics in front of me, but what I can say is that public charge functioned as one of the primary ways for excluding immigrants precisely because of how elastic it was. So as an example, during the 1930s, public charge excluded more German Jewish refugees trying to escape from Nazi Germany than the national quotas laws did, precisely because it was so broad. At that point in time, President Hoover was looking for a way to further curtail immigration. So he goes to the State Department and he says, okay, we can't pass more immigration laws. We've already passed national origins acts, and there's just not that much more we can do without creating a great deal of difficulty. So the State Department says, hey, here's public charge. We've used it to great success over the past roughly 30, 40 years. So all we have to do is enforce it more stringently. So it ranged from anywhere from hundreds to thousands of immigrants, depending on the decade and how restrictive the United States was being at that particular time on immigrants. And it also depended on the particular country. So some countries relatively few suffered the impact of public charge. Others, especially Eastern Europe, Southern Europe, you saw considerably higher numbers simply because it granted immigration officials a tremendous amount of leeway to administer it as they chose.
So perhaps related then, we have another comment that says, first of all, excellent, such deep research. How can you place the work of Kohler, Sadie American, A. Elkus on behalf of Jewish individuals into a broader context? That is, while you're writing about Jews, Jewish communities, and advocates, what about the millions of other immigrants, non-Jews? Were there similar aid organizations and energetic advocates for others? Whether we think about groups, for example, Italians, Greeks, and so on, or about immigrants more generally. And the questioner is also interested in references to Oscar Strauss, an individual who surely would have been in Kohler's extended social circle.
Definitely. I wanted to discuss Oscar Strauss in more detail, but I did not want to hold the audience hostage for longer than absolutely necessary. So I will do that in the dissertation. So Kohler himself worked a great deal, as I mentioned, on Chinese exclusion and Japanese naturalization cases. So he was particularly interested in racist exclusionary law writ large. So while he's focusing especially on Jewish immigrants in the examples I have here, in the archives, there's also like a whole boatload of cases where he is assisting Chinese, Japanese, South Asian, and Indian immigrants as well, who are trying to get into the United States and are not able to do so because of federal law. According to HIAS, which admittedly is a Jewish organization, when they went to visit Ellis Island during William Williams' tenure, they claimed, based on looking at the limited records that Williams would supply, because he allegedly was, and I'm quoting directly here, scared of Max Kohler. They said the Jewish organizations are the most effective at combating immigration officials and getting immigrants in. So while, of course, the Jewish immigration organizations primarily focused on Jews, these individual attorneys did not necessarily.
Our next question comes from someone interested in the ableist framework. Their question is, did Kohler ever exhibit any awareness of the fact that his advocacy implicitly validated the ableist framework of public charge? How did he engage with that situation in which validating it was the only viable way forward in defending his individual client?
Yes, that's a question I struggle with a great deal myself. So Kohler was very savvy. In my reading, what I've seen is that he does not contradict the underlying idea of public charge, which incidentally has not changed into the present day. Public charge still exists, and the majority of pushback against it is to claim, no, we're not disabled, therefore it doesn't apply to us, not, hey, why should illness or disability even matter? I would point, for example, there's Reagan's HIV ban, there's the Trump administration's recent extension of public charge to apply to immigrants in this country. So no, I wish, personally speaking, that Kohler took more issue with the ableist framing of the law than he did, at least in his public writings. I have not seen that, but also in fairness, I suppose, I really have seen very few people do that into the present day, because the framing of American legislation writ large is so intrinsically ableist.
And then a question that might be particularly interesting to many of our fans of YIVO in the audience, which is if you could speak to some of the documents that you used to look at Bluma and Pauline's cases by using the YIVO archives.
Definitely. So my favorites by far to look at were the briefs and all of the various court records. There's also some fascinating slips from HIAS that detail all of the reasons for which immigrants were certified as defective and ordered excluded. So those included things like poor physical development, underweightness, hernias. Quite literally, I think there was one where one immigrant had one leg was slightly shorter than the other leg, things of that nature. So these highest case slips were absolutely invaluable. Also, Kohler was a major player in Baron de Hirsch, the Baron de Hirsch Fund. So looking at his role presenting to these other organizations really framed a great deal of my understanding of how he engaged with these cases specifically. So it really provided a much broader portrait of the landscape in which Kohler was acting and how other Jews were dealing with these same issues at the time. Because from the YIVO papers, it became apparent that Kohler was pushing the envelope a little bit further than his other contemporaries, specifically as regarded public charge. Some of the other lawyers, Simon Wolf, for instance, didn't quite seem to get why it was such a big deal. Whereas Kohler was like, we simply cannot allow this not because it is ableist, but because it contravenes the Constitution and fundamental American ideals of justice and liberty. So YIVO was massively helpful in providing this broader landscape in which Kohler was operating.
And our final question for today, we have some folks interested in continuing to hear more from you. I'll note for anyone interested that this lecture is being recorded and posted on YouTube. So if anyone wants to rewatch certain elements or share it with friends, they're welcome to do that. But Hannah, how may people continue to be informed about your research? There's questions of if you are working perhaps on a book or a documentary, and how can we kind of continue to learn from this topic?
Yeah, definitely. I'm happy to drop my email in the chat if that is something that everybody sees, which I'll do right now. Okay. For those who aren't able to see it, it's Hannah, HANNAH.Greene, GREENE, at nyu.edu. Please absolutely feel free to reach out at any point in time. Fingers crossed, this will be a dissertation within about the next year. And it also, fingers crossed, will ultimately be a book. So by all means, I welcome any and all feedback, questions, thoughts. If anyone is a documentary maker, sure, I would love to make a documentary. If anyone happens to know like Lin-Manuel Miranda and wants to make a musical out of this, by all means, please be in touch. I think that would be amazing. So I am fully open. Additionally, I do have some side research published in the journal American Jewish History on Lillian Wald and birth control, who is one of Kohler's contemporaries and unfortunately did not fit into this talk. But if you're interested in that side of things as well, because of course it all connects to this ableist and political framework, that is also available in the most recent issue of American Jewish History.
Wonderful. Well, I would like to thank everyone for joining us today at YIVO for today's Max Weinreich Fellowship Lecture. Thanks again to our funders and for all of you for attending. We hope you choose to learn with us again in the future. You're welcome to register for upcoming events with wonderful lectures like today's on YIVO's website at yivo.org. Thanks.
Thank you so much.